Warren Mills.
Good morning, yes,
And Mr. Mills, in cause number 25 DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
I understand that.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plea.
Yes,
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, Your Honor, ma'am. I want to reject it, and then I wanted to see, at that point in time, I was, I was incumbent at one.
Right away, you can tell this judge is being extremely careful here. She's making sure the defendant fully understands the risk before rejecting the plea deal, and legally, that matters. If this case goes to trial later, nobody can say he wasn't warned about what was on the line. But here's the real tension. 8 years may sound brutal, until you realize a trial conviction could hit way harder. So what would you do? Gamble on a jury, or lock in the deal before things get worse?
Okay.
I was out of my mind, which I have a history of it before.
Okay. Okay.
But I just wanted to say on docket for everybody that in my mind, my heart, my mind was so I would never hit office.
Well, so
this is a situation that I'm in.
The allegations allege alcohol and drugs.
And is there a video?
That's what I was asking. I wanted to.
Hold on.
I didn't see a video on Discovery. There may be, but I don't.
I have a
see
thumb drive in my car.
Let me do this. So before we move your case to the trial docket, I'm going to let Mr. Parker have some time to get a copy of that video. And then he can come show it to you. You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay? If you still want to go to trial after you see the video.
Excuse me, I really don't want to go to trial.
Well, that's what... I want you to see everything. I'll give them some time to get that taken care of, and then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
Okay, thank you.
All right, you can go back with the
Can I
bailiff.
ask you one more question?
Yes, sir.
In the situation, did probation ever come across the table?
That's between your lawyer and the district attorney's attorney. It's whether or not they offer it. Okay. I'm just going to delete the rejection. If it's we'll do it again later if that's the case. All right. Good morning, sir. Are you Samuel Jones?
Yes.
And Mr. Jones, in cause number 25 DCCR 0043, you're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2020.
This is a surprisingly important courtroom moment. The judge immediately slows everything down once the defendant mentions mental health and questions the video evidence. Why? Because body cam footage can completely destroy a defense or completely change the direction of negotiations. And notice how the judge doesn't pressure him into pleading guilty right there. She wants him to see the evidence first. That tells you she already suspects a video may be stronger than he realizes.
4. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment, guilty, and those prior offenses are true, is 25 years in prison, up to 99 years or life. Do you understand? And I need you to answer yes or no, please.
Yes.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible... Okay, let me finish. I want to make sure you understand your consequences possibly and what your options are. And you want to reject that offer and have both cases. And so you also have, and let me go through this too just for the record, in cause number 25 DCCR 0232, you're charged with burglary of a building and state jail felony. And that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand? Okay. And you want to reject that offer and have your case set for trial.
Yes.
All right.
And I like to indict everybody who have witness. I like to indict everybody who caused this case, signed the case.
Okay. So
fingerprints, evidence, and everything. I want everything to be.
Okay, this is where the hearing starts taking a sharp turn. The defendant suddenly jumps into badge numbers, investigations, indicting everyone in the courtroom, and judges are trained to watch for exactly this kind of behavior. Not because being emotional is illegal, but because the court has to determine whether someone genuinely understands reality, the charges, and the legal process. And once competency becomes a concern, the entire criminal case can hit the brakes instantly.
He's complained about some charges that other counties have complained that doesn't have anything to do with here.
So here,
everybody here, and I told him everybody will have to be here at trial whenever.
yeah, I mean, whatever the district, listen.
I'm 17 code, my code is 774 is my badge number. 477, Barras, Bear County, Patrol Detention.
Okay.
Private detective and everything.
Okay.
Private investigator.
All right. So here's what we're going to do before we move any further with this.
And this is where courtroom reality hits hard. A competency evaluation can completely pause the momentum of a criminal case. If the court believes the defendant may not fully understand the proceedings, everything shifts from can the state prove the crime?
And there it is, the competency evaluation. This is one of the biggest pivots a criminal case can take. At this point, the focus temporarily shifts away from guilt and toward mental fitness. Can the defendant understand proceedings? Can he help in his own defense? Because if the answer is no, the trial can't legally move forward. You can literally feel the courtroom energy change here from punishment to evaluation.
2. Is this person mentally capable of standing trial at all? That's a massive legal turning point. And honestly, you can feel the entire energy in the courtroom change the second the judge makes that call.
I'm going to, Mr. Jones, I'm going to have someone talk to you to make sure you're competent to stand trial, get all your history, make sure we're all good before we go to trial. When they visit with you at the jail, either in person or on the computer, you need to make sure and cooperate with them, and then we can move your case forward, okay? All right, go back with the bailiff, please. Everybody keeps, y'all just wait, I'm going to get everybody. All right, are you Evan Bowden? Mr. Bowden, you're charged in each of your cases.
Now, this is the kind of legal strategy most people never hear about. The attorney isn't fighting the plea itself. He's trying to avoid triggering a probation revocation in another county. One guilty plea here could create a domino effect somewhere else. That's why criminal defense can feel less like one case and more like a giant legal balancing act where every move affects another board.
With evading arrest or detention with the use of a vehicle, and what is the announcement?
Your Honor, this is the case where he also has a pending motion of probation out of Chambers County. I've been trying to work something out with him. The prosecutor handling that case is Eric Carcerado, who's currently in Austin for a legislative issue right now. I call it.
This is.
I know, but if I plea him out to this, Your Honor, that's automatic revocation over there, and he's getting. I know it doesn't affect his court, but it does.
I mean, you've been on the case since June of last year.
I know.
So here's what I'm going to do. I'm going to reset it 2 weeks.
Oh, that's fine.
And that is the final reset.
Like I said,
hold on. It's either going to trial or it's going to get taken care of on that day.
I'm saying the offer that the state's made, we want to accept. We like it. It's great. It's just a matter of I don't want to do something here that's going to automatically send him up there.
Well, I'm sure he hasn't.
And this is a hidden side of the justice system people rarely see online. Most criminal cases aren't explosive courtroom speeches or surprise witnesses. They're pressure, negotiation, mental evaluations, sentencing risks, and attorneys trying to minimize damage before trial even starts. But here's the question. If you were staring a decade behind bars, would you risk everything hoping a jury believes you or take the deal and guarantee the outcome?
Been in Austin this whole time.
No, it's just been since our last resetting.
All right.
So.
You can go back with the bailiff.
Yeah, we'll get something done in that amount of time.
What makes hearings like this so fascinating is that almost none of these cases are actually about dramatic surprise evidence. They're about negotiation, pressure, timing, and risk management. One defendant is weighing prison against trial. Another may face competency questions, and another is trapped between two different counties and probation consequences. This is the side of the justice system most people never see the chess. Match happening before a jury ever enters the room. The big question is, if you were facing decades in prison, would you gamble on a trial or take the deal?